Okay, I want to talk about one more case about rational basis review that applies to non-suspect classes before we get to the issue of ethnicity, which is the first group we're going to, or the first characteristic, the first classification that we're going to study, which I should say is going to be the first suspect classification that we're going to study. So first I want to look at New York City Transit Authority versus Beazer on page 1358. We can't get away from New York today. Here we have the New York City Transit Authority, and you want to kind of give that some thought. The New York City Transit Authority, what they're responsible for, right? They've got the buses, the subways, the ferries. There's all kinds of ferry services in New York City. So the New York City Transit Authority is responsible for running all of those vehicles and programs. The New York City Transit Authority has a policy that excludes methadone users from working for the TA, the Transit Authority. Methadone is not to be confused with methamphetamine. I've had people confuse that before. Methamphetamine is what we usually call meth. Methadone is something different. Methadone, whenever we're in live class sessions, people who have worked in the law or law enforcement, or people who have worked in public health, usually know what methadone is. Methadone is a drug that is taken usually by people who are trying to overcome opioid addiction, and particularly heroin. So we know something about people. If somebody's taking methadone, there is an inference, and it's a reasonable one, that that person is struggling with heroin addiction. Now, speaking of people who have ever worked in law enforcement, you know, if you've ever been in criminal defense, if you've ever been a prosecutor, police officer, anything like that, you know that heroin addiction is nasty. If you want to, I tell people, I used to tell clients too, you want to ruin your life in one simple step, try heroin once. Many heroin addicts will tell you that as of the first time they tried it, their life was over. So it's a terrible drug to try to kick. That being the case, there's a high level of relapse and recurrence. And that probably is what drove the Transit Authority's decision not to have people who are using methadone working for the Transit Authority. Now you see here, this is not as easy of a case as the last two cases we talked about. The Railway Express case out of New York and the Dukes case out of New Orleans, it was pretty clear in those cases that we're not dealing with a suspect classification or any kind of animus or irrational targeting for arbitrary reasons. There's a debate here among the justices whether maybe that is what's going on here. And Justice White in particular thinks that maybe there's something else going on here that we'll talk about later in the term, which is that even though this policy of excluding methadone users looks neutral on its face, that it might actually be targeted to minority communities, or at minority communities. Having noted the debate among the justices here, let's, however, take a look at what happens when the Supreme Court decides that lower courts were applying too much scrutiny. So you're getting used to this by now. You've got to know what level of scrutiny we're applying. What the Supreme Court seems to say here to the lower courts is you were applying a heightened level of scrutiny. You were scrutinizing the law. You were looking for whether the law was overbroad, whether it excluded too many people. And you only do that, you only look at whether the law is overbroad or it's a little bit off in terms of the means-ends match if you're applying some heightened scrutiny test. So really it comes down to here, what level of scrutiny should courts have been applying and why? So we'll go through the analysis one more time. We have, first you cite the text, and here we have the city of New York. Once again, New York is a state actor, there's no question about that, and the 14th Amendment applies to the state of New York and its subdivisions on its face. Then you look at the classification. The classification here is methadone users. Again, you know, in substitute process, you have to argue about what you call the right. You kind of get out of that in the equal protection cases. Look, when you look at a law, a program, or a policy, and what group it targets, there's really not a whole lot of debating this. It targets methadone users. That's the group. So you move to the next step. right, in your mental checklist of how to do a standard equal protection analysis is, has the Supreme Court ever said that methadone users are a suspect class? Of course not. So the question is, should it be? Now here, you can actually get into a little bit of a debate. Is drug addiction an immutable characteristic? Well, if you talk to a social worker or a medical professional, they might tell you that once you become a drug addict, I mean the word addict, and we use the words recovering addict, you never take the word addict off. Somebody can be a recovering addict, but it's still an addict, because addiction doesn't go away. It's not changeable. So in a sense, it is an immutable characteristic. It becomes an innate part of somebody that somebody can control, right? But it doesn't totally go away. So in some senses, you can argue that it's an immutable characteristic. It can't be changed. On the other hand, you have to remember all the time when you're practicing law that who your audience is. Your audience is judges, and I don't think there's a judge in the country who's going to say that drug addiction is an immutable characteristic. Most judges are going to say what? Once you become an addict, maybe that can't be undone, but the choices that, unless somebody's force-fed drugs or other substances, the choices one makes along the way to becoming an addict are certainly not immutable. That's not an immutable characteristic. It involves conduct and choice. So when we're trying to decide should methadone users or drug addicts more generally be a suspect class, the immutability factor is not going to cut in favor of saying yes. Is there a history of political powerlessness? And I have characterized that in former videos and lectures as a history of targeting people. Now here we do have, this is why I say this is a little closer call, because you can say, all right, we do have a long history, and now we're starting to revisit it, by the way, of targeting people based on drug use and criminalizing addiction. But again, when your audience is judges, you're not going to have a really sympathetic ear most of the time arguing that history of punishing the use of drugs was meant to arbitrarily target people. Instead, most law enforcement people and most judges are going to say, that our history of punishing and criminalizing drug use is not a history of arbitrary targeting people for sport. We'll revisit that idea. It's kind of like saying, well, there are speeding laws. Speeding laws have targeted speeders for decades. Well, okay, we have speeding laws that target speeding, but that's the point. They're not targeting speeders, they're targeting speeding. And most courts are going to say that drug laws are not, they're not targeting the people who use drugs, they're targeting the conduct of using drugs. So there you go. This might be a closer call than in some of the other cases, but again, the court is not going to be impressed with this. Now, we get to factor number 3 when you're deciding whether something should be a suspect classification. And finally, we run into a case here where it looks quite relevant. That factor looks like it's in play. And why is that? If the characteristic that's targeted has something to do with a person's ability to contribute in a certain way, then it's less likely that a court is going to say it's a suspect classification, that there's an equal protection violation going on. So the question here is, because now you're looking at, again, rule trigger, is the characteristic has something to do with a person's ability to contribute, facts, methadone users being excluded from jobs with the transit authority. Okay. So, methadone, again, is used by people who are trying to kick heroin most of the time. And so somebody who is using methadone, unfortunately, there is a probability of relapse into drug abuse. The jobs that we're talking about here are either the people who are driving these things, right? Driving the train, driving the bus, piloting the ferry, right, those people, or the people who are responsible for maintaining these instrumentalities of commerce, remember that? So either way you slice it, it doesn't seem like there's no relationship between the classification and the way in which people are being asked to contribute. This is kind of like the height restriction for pilots that I keep talking about. Well, if you want to be a pilot, you have to be a certain height. Well, if you want to pilot a ferry, drive a bus, drive a train, or maintain one of those instrumentalities, you're going to have to be sober. And being a methadone user makes it less likely that the person is going to maintain sobriety. So, and again, this sounds a little bit heartless, but you'd have to look at all of that in determining whether this should be a suspect classification. Now, the bottom line is the majority on the court treats this as a non-suspect class, and therefore rational basis review applies. And I hope you read this case carefully. This is what happens when and I said this earlier, when the Supreme Court says lower courts seem to be applying a close level of scrutiny to this. They were looking for a very good means-ends fit. And here, lower courts concluded that the fit wasn't quite justified, that the exclusion was overbroad. Now, when you're applying strict scrutiny, then you're asking for means that are narrowly tailored. So if the means are overbroad when you're applying strict scrutiny, you're dead in the water if you're the government. I hope you get that. Narrowly tailored is the opposite of overbroad, right? So once again, we see how important it is what test you're applying. The court here is saying, what, if you were applying strict scrutiny, if you were applying intermediate scrutiny, then maybe there'd be a reason to strike down New York's policy here. On the other hand, you're supposed to be applying rational basis review. Is there a legitimate interest? Of course there's a legitimate interest. There's even a compelling interest in saving lives. I mean, who's on the ferry? The children, okay? You said that before I did, I hope. Who's on the train? Who's on the bus? So there's no question that public safety is a legitimate interest. It's higher than that, but all you need is legitimate. So the only question is whether this is rational. Is it rationally related? And the court here says, the lower court said it wasn't rational enough. Well, under rational basis review, if it's rational at all, okay, this is an important point. If it's rational at all, if there's any relationship at all between the means and the ends, then the law is good. And the court here says there is. There's enough of a relationship between the classification and the means. The means is excluding people who are methadone users. That is rationally related to achieving public safety in public transit. Therefore, again, the law is upheld. And so you see one more time how to run through that analysis. It's worth the repetition to go through this over and over and over again. I mentioned before, the bar examiners would love to throw non-suspect classes at you to make sure that you know how to apply rational basis review just as well as you know how to apply higher levels of scrutiny. So that's enough for this video. Again, after this, we're going to pick up with our first suspect classification, which is ethnicity. We're going to start with what I call the trio of terror, which is the Dred Scott, Plessy versus Ferguson, and the Korematsu case. We'll move from there to Brown versus Board of Education, which sets up the modern analysis. So until then, as always, stay well and stay tuned.